The kitchen was quiet when I walked in, but it was the kind of quiet that had a shape to it. My father sat at the head of the table. My mother folded a paper napkin into squares she did not need. My brother Evan was already eating. My court folder was still in my hand. I had met with a legal aid attorney because my parents were suing me over the house I bought after my divorce. Dad looked at me and said, "You never keep anything unless someone stronger lets you." By that night, I had spent $4,860 on legal fees, lost 2 shifts at work, and learned that my parents were asking the court for my savings records, my furniture list, and even the old truck I had paid off myself. Nobody said a word for me. What my parents still did not know was that one signed document in my folder could destroy the story they had built. 3 weeks later, the truth would come out in front of a judge, a bailiff, and half my family. Have you ever sat at a family table and realized they had chosen you as the one they could strip clean? I stayed standing because there was only one open chair, and it had been turned away from the table like a warning. Mom said, "Dinner's getting cold." The casserole dish sat between Evan and Dad. My plate was still in the cabinet. My mother only left it there when she wanted me to understand something without hearing it said aloud. I got the plate myself and sat down. Evan gave a short laugh. "Still dramatic," I said. "You seem happy about this." He shrugged. "You started it. I filed to keep Dad out of my house. Dad cut in. Your mother has a key because it used to be our house. It stopped being your house when I paid you the last $72,000. Mom kept folding the napkin. My father never shouted when he wanted control. He spoke like a man correcting numbers on a bill. Dad said, "We helped you after the divorce. We gave you a chance to buy that place below market value. We carried you." I said, "I paid every cent we agreed on. You paid what we allowed," he said. There it was. The old truth under every other truth. Nothing I had ever had was supposed to count if they could still take credit for it. Mom finally said, "Your father wants fairness." Fairness had always fed Evan first. When I was 16, he got a car and I got a bus pass. When he dropped out of graduate school, my parents covered 11 months of his rent. When my marriage ended, they sold me a leaking house and told everyone they had rescued me. Maybe my parents thought they were practical. Maybe this was how families taught one child to stay grateful while the other one stayed entitled. Dad reached for the breadbasket. "The court will see this clearly." I said, "See what clearly?" "That you were never in a position to manage an asset like that house." The room went still. I said, "I have owned it for 4 years. "You occupied it," Evan said. I looked at him. "You've borrowed money for 14. Dad leaned back. "This bitterness is why you fail." I thought that was the low point. I was wrong. My father slid a yellow legal pad across the table. He had written out columns in dark ink, taxes from before I owned the house, estimated repairs he never made. A line marked parental labor. The total at the bottom was $118,400. I stared at it. Mom said softly, "We are not trying to hurt you." I said, "You filed a claim against my property." Dad replied, "Because you forced this into a public process. Public mattered more to him than truth ever had." By then, he had told my Aunt Linda I was unstable. He had told our pastor I was confused after the divorce. He had told 2 cousins I was trying to steal family property. Then Dad reached into a manila envelope and laid an old copy of the deed on the table. Not mine. The old one with his name and my mother's. He tapped it once. "This is the real history," I said. "The updated deed is recorded with the county." He smiled without warmth. "Paper can be corrected." That sentence stayed with me because 3 days earlier, someone at the county clerk's office had called me back after I requested certified copies. She said an inquiry had been made about whether the transfer could be challenged if coercion or misunderstanding were alleged. She told me to bring every document I had. At the time, I thought the problem was the house. I found out later it was bigger than that. Evan said, "You should settle before you embarrass yourself." I said, "I am not the one asking a judge for a couch." He smirked. "Mom picked that couch." Mom finally looked up. "That dining set was always meant to stay with the family." The dining set had belonged to my grandmother. 6 months before she died, she gave it to me. I remembered that when I found her lawyer's card tucked inside an old recipe box last month. A small thing. Not small at all. Dad saw me touch my folder. "What's in there?" "Receipts," I said. That was true, but not all of it. Mom stood to refill water glasses. She filled Evan's first, then Dad's, mine last. Dad said, "You always turn a family correction into a spectacle." That was his phrase for everything. When he emptied my college fund to cover Evan's second failed business. When he used his old key last month and photographed my living room for evidence. I looked at him and said, "You are not correcting anything. You are trying to take what you can before anyone sees what you did." Nobody moved. Even Evan stopped eating. Dad smiled. "Bring whatever papers you think will save you." I carried my untouched plate to the sink. In the dark window above it, I could see all 4 of us reflected back at me. My father seated. My mother turned away. Evan watching. Me standing alone with my court folder. 3 days later, the county packet arrived, and that was when everything started to change. Would you have left that table quietly? Or said the one thing you could never take back? The county packet was waiting on my porch when I got home, damp from morning fog. I opened it on my counter. Inside were certified copies of my deed, the sale contract, and a notice I had never seen. It was a request for review filed 12 days earlier by my father. He had alleged incapacity, coercion, and recording error. Under that was another page showing a proposed corrective filing that would have added his name back to the title. My hands went cold. That wasn't the worst part. Stapled behind it was a property contents sheet, room by room. My sofa, my grandmother's sideboard, the washer I bought after the divorce, even the framed mirror in the hall. My father was not just preparing for court. He was preparing to empty my house. Then my phone lit up. It was my Aunt Linda. She said, "I heard things got ugly. They sued me." She lowered her voice. "Your father said you were hiding documents." I looked at the packet. He filed to put his own name back on my house. Silence. Then she said, "Your mother told me not to get involved." That sounded like her, a warning dressed up as helplessness. When I asked Linda if she knew anything about the county filing, she hesitated. Then she admitted she had seen my father at church with a man from the title office 2 Sundays earlier. That mattered, not because I knew what it meant yet, because it meant he had started moving pieces before I even understood the game. I called the legal aid office. The assistant told me to gather every payment record, every receipt, every text, and every witness who knew the house had been sold to me outright. Witnesses. That word sat badly in my chest. People liked me well enough when no one had to choose sides. Court was different. For a while, things were quiet. Then my doorbell rang. Evan was on my porch with his hands in his pockets like he was there for a casual visit. I kept the door half closed. He said, "Dad's offering a settlement." I waited. "He keeps the dining set, the sideboard, and the truck. You keep the house if you refinance within 90 days. I said, "He wants me to pay again for what I already own." He says it's a clean reset. A clean reset would be him leaving my property alone. Evan leaned on the frame. "You know he'll never let this go unless he wins something." There it was. Not fairness. Tribute, I said. "Then he can lose in public." His face tightened. "You always make him dig in." I looked at him and remembered years of the same pattern. Evan protected. Me corrected. One child cushioned. One child instructed to be grateful. Have you ever watched one sibling get protected so often that the whole family starts acting like protection is the same thing as truth? Evan said, "You could still walk this back." "You mean Neil. He's not bluffing. Neither am I." He left without saying goodbye. After he drove away, I walked room to room with the inventory sheet in my hand. Living room, hall, spare bedroom, kitchen, back porch. I stopped at the sideboard and opened the top drawer. Inside was the recipe box, where I had found my grandmother's lawyer's card. I took it out again. Harold Bell, Esk. The office still had a number on it. I called. When Mr. Bell came on the line, I said my grandmother's name and there was a pause. "I remember her," he said. "She gave me your card. Then she wanted you to find me." That sentence made me sit down. I told him about the lawsuit, the title inquiry, the inventory, and the old deed my father had waived at dinner. He listened without interrupting. Then he asked one question. "Did your father ever mention a family trust?" I said no, he wouldn't. The room seemed to tilt. Mr. Bell told me my grandparents had placed the house into a family trust years earlier. My parents could manage it for tax purposes, but they could not reclaim it however they pleased. When the house was transferred to me, the trust required written acknowledgement that I had purchased it as sole owner, and that no corrective claim could be filed without 2 trustee signatures and notary review. I said, "My father filed one anyway. I had a feeling he might." Then he said something worse. "Your grandmother left an affidavit. She was specific about your father's habits." I tightened my grip on the phone. "What habits?" "Revision," he said. "Control. Rewriting promises after other people had paid for them." It was the most exact description of my father I had ever heard. Mr. Bell told me not to surrender any furniture, not to sign any settlement, and not to let anyone from my family inside my house again. I said, "They already used the old key. Change the locks tonight." So I did. I drove to the hardware store before closing and bought 2 deadbolts and a motion light for the porch. Back home, I changed the lock myself and watched the driveway through the window while I worked. After that, I opened the metal cash box in my closet and found the papers I needed: payment stubs, bank statements, the final cashier's check from 4 years earlier, my name, my account, my proof. I thought that would calm me. It did not. Because the more paper I found, the clearer it became that this was not confusion. It was a plan. Near midnight, my phone buzzed again. A new email from my father. One attachment. No greeting. The subject line said, "Final offer." Inside was a settlement draft giving him access to disputed property pending final determination. He listed my house keys, the truck title, the dining set, and the sideboard. At the bottom, he had written one sentence. "You should be grateful we are trying to do this quietly." I forwarded it to my attorney. The next morning, Mr. Bell called back. He had found the trust file, my grandmother's affidavit, and one detail no one in my family had mentioned to me. My mother was not a silent witness in this case. She was the second trustee, and without her signature, my father's filing should never have reached the county at all. Would you have signed something to stop the war, even if the price was letting them say they had been right all along? Rain hit the courthouse parking lot the morning I met Mr. Bell in person. He was older than I expected, with a leather briefcase worn pale at the corners. He led me to a bench outside the records office, opened the trust file, and turned the pages. There was the original trust agreement from my grandparents. There were the transfer instructions. There was the acknowledgement of sale showing the amount I paid, the installment schedule, and the line stating that full ownership would pass to me upon final payment without future claim or family reversion. Then he showed me my grandmother's affidavit. Her signature was shaky, but the words were not. She wrote that my father had a pattern of revising oral promises to serve himself, that he treated money as leverage over his children, and that if any dispute arose after her death, records held by her attorney should be treated as more reliable than family recollection. She also named property she wanted protected, including the dining set, the sideboard, and the recipe box. Mr. Bell said, "Your grandmother understood your father better than most people ever would." I said, "Then why did she leave him in charge of anything?" "Because families confuse proximity with trust." He handed me another document, a trustee consent form. My mother's signature was on the original transfer 4 years earlier. Right below it was a note from the notary, confirming both trustees had appeared together and acknowledged the sale as final. My mother had signed. She knew. Her silence at dinner was not ignorance. It was participation with the volume turned down. Mr. Bell closed the file. "You may need the notary too." "The notary is still alive." He nodded. "Elaine Porter, retired, lives 20 minutes north." At lunch the next day, my phone buzzed with a voicemail from Dad. I listened in my car. His voice was flat. "You never keep anything unless someone stronger lets you. Call me before you make this worse." There it was again. I deleted the voicemail, but the line stayed. The next morning, I drove to see Elaine Porter. Her house sat behind a white fence with 2 cracked flower pots on the porch. She remembered the transfer meeting. She remembered my mother sitting silent. She remembered my father doing most of the talking. And she remembered one more thing. After the sale was complete, my father had asked whether a later correction could ever be filed if the girl became unstable. Elaine said, "I told him only in cases of recording error or mutual consent." He did not like that answer. I asked if she would testify. She looked at her folded hands. "If I am called, yes. Have you ever found out the person who stayed quiet in your family knew the truth all along and still let you stand there alone?" I thought that was the turning point. I was wrong. 2 days later, my attorney called while I was at work. The court had ordered disclosures before the hearing. My father's filing now included a scanned trustee memorandum dated 8 months earlier, stating the transfer should be reconsidered due to beneficiary instability and family need. "There's more," my attorney said. "The signature on it is your mother's." That was where the whole case changed shape, because if my mother had signed it, then both my parents had tried to build a paper trail behind my back. But if she had not, then my father had moved into fraud. I drove home in a fog and found my mother's car waiting in my driveway. She was standing by the porch with her purse in both hands. I did not invite her in. She said, "I need to talk to you." I crossed my arms. "About the forged memorandum." Her face changed before she spoke. That was all I needed. She looked over her shoulder as if my father might be behind her. "I did not know he filed that." "Did you sign it?" "No. He brought papers to me in January," she said. "He said they were tax papers for the trust. I signed 1 page, maybe 2. I did not read them closely." I laughed once. "You signed trust papers without reading them." She flinched. Then she said the thing that made me angrier than anything else. "I thought he was trying to protect the family." I said, "You mean protect him?" Mom looked down at the porch boards. "He said if the house ever had to come back, it should come back clean." "Come back from what?" "I paid for it." She whispered, "I know." There was silence between us. Then she reached into her purse and pulled out a folded bank envelope. "I found this in your father's desk," she said. "I should have given it to you sooner." Inside was a copy of a check from 8 months earlier made out to a private title consultant for $3,200. In the memo line were the words, "Deed Review." I looked up at her. She was crying by then, but quietly. "I never meant for this to go so far," she said. Maybe she believed that. Maybe she had always believed that silence delayed harm instead of feeding it. I took the envelope and said, "If you want to help now, you tell the truth." She nodded once and walked back to her car without asking to be forgiven. That night, I sent the check copy to my attorney. Mr. Bell called 10 minutes later. "Now we have motive, timing, and outside involvement," he said. The next morning, the court clerk called to confirm witness attendance, and I heard the hearing described with one word that made my pulse jump: evidentiary. This was no longer going to be a family disagreement dressed up as paperwork. This was going to be a record. By the end of that week, my attorney had listed Mr. Bell, Elaine Porter, and my mother as possible witnesses. My father responded by filing a motion accusing me of instability, desperation, and harassment. He asked for immediate access to disputed household contents pending judgment. I sat at my kitchen table that night and read his statement 3 times. I looked at the deadbolt I had installed myself, the stack of payment stubs beside my elbow, and the old recipe box near the fruit bowl. Historically dependent. Not anymore. I still do not know whether my mother believed her own apology in that moment, or whether silence had simply become the only language she knew. The hallway outside courtroom, 4B, smelled like wet coats, old paper, and coffee. I got there early with my attorney, a banker's box of documents, and a stomach that felt hollow. The benches were half full of ordinary damage waiting under fluorescent lights. Then my family arrived. Dad came first in his gray suit, carrying the same leather portfolio he used for church meetings and funerals. Evan was behind him. My mother walked last, pale and careful, with both hands around her purse. Nobody greeted me. What was new was the way Dad looked around to see who might be watching before he spoke. He was performing calm now. Calm for the court. Calm for the record. Calm for people who had never seen him at a dinner table or standing in my living room with an old key in his hand. My attorney leaned toward me. "Do not react to anything unless I tell you to." I nodded. 10 minutes later, my father crossed the hallway and stopped in front of me. He said, "There is still time to stop this." I stayed seated. He looked down at the banker's box by my feet. "You are making yourself look unstable." I said, "You already tried that in writing." His jaw tightened. Then he lowered his voice. "You never keep anything unless someone stronger lets you." There it was again. I looked up at him and said, "That is why you are scared." For a second, something slipped in his face. Then the bailiff opened the door for settlement conference. We were sent into a side room with a long table, a box of tissues, and a dead ficus in the corner. The mediator was a tired woman with reading glasses on a chain. She asked both sides if there was any chance of resolution before the hearing. Dad spoke first. He said he wanted family peace, preservation of inherited assets, and protection against my recent volatility. He said the house sale had happened during a vulnerable period in my life and that everyone had only been trying to help. When it was my turn, I placed the trust acknowledgement, the payment ledger, and the cashier's check on the table. Then I placed the county filing with his proposed corrective deed, the $3,200 consultant check, and the inventory list. I said, "This is not concern. This is a recovery operation." The mediator read in silence. Dad said, "She is exaggerating ordinary family confusion." My attorney slid one more page across the table. Elaine Porter's signed statement describing his question about whether the deed could be corrected if the girl became unstable. The mediator looked up. Dad did not touch the paper. Then he leaned back and said, "She always collects sympathy from outsiders." My mother flinched. The mediator asked my mother whether she disputed the original transfer. Mom opened her mouth, then closed it. Finally, she said, "I signed the original sale." Dad turned toward her slowly. She kept looking at the tissue box, and I did not knowingly sign any memorandum, asking for it back. No one spoke. Then Dad smiled, but it was a damaged smile. "You do not remember half the papers you sign." Mom's hands tightened around her purse. But she said, still without looking at him, "I remember enough." The mediator ended conference 10 minutes later. No settlement. As we filed back into the hallway, Evan caught up to me by the water fountain. He said, "You are enjoying this." I turned to him. "You really believe that?" He shrugged. "You always wanted a scene." I said, "No, your father wanted privacy. That is different." Evan's face hardened. "He did everything for this family." I said, "He did everything for his version of it." Then the courtroom doors opened. Inside, the room was colder than I expected. Dark wood, state seal, witness stand to the right. I took my place beside my attorney and set the banker's box on the table. The hearing started with names for the record, claims, and ordinary procedure. My father looked composed while his attorney talked about family accommodation, emotional instability, and disputed intent. He sounded almost reasonable if you had never lived with him. Then our side began. My attorney walked the judge through the payment ledger first. Installment dates, bank records, final cashier's check, then the trust documents, then the original trustee consent, then Elaine Porter's statement. Then the proposed corrective deed my father filed without proper authority. The judge asked why the county filing appeared to lack a required trustee acknowledgement. My father's attorney said they believed later consent would be established. Believed. That word hung there. Then Mr. Bell took the stand. He identified the trust file, my grandmother's affidavit, and the protected property list. He explained that the transfer to me had been structured precisely because my grandmother feared later revision. He said she had spoken at length about my father's habit of treating family help as revocable long after money changed hands. Dad stared at the table. Then Mr. Bell identified the dining set and sideboard as protected items my father had later claimed were family assets subject to return. That was one layer. Then came another. My attorney moved to admit the $3,200 consultant check and the title review correspondence subpoenaed the week before. The consultant had been hired to explore ways to challenge or delay my recorded ownership despite completed payment. The room changed. Dad finally looked at me, not like a father, like a man watching a door close. The judge said she wanted live testimony from the notary before ruling on the filing issue. Elaine Porter had been waiting in the hall. The bailiff went to bring her in. And that was when my father muttered something to his attorney, shoved back his chair, and stood too fast. The judge looked up sharply. My father said, "This is turning into an ambush." The judge said, "Sit down, sir." He did not. He turned halfway toward the door as if he might stop the next witness from entering. The bailiff stepped forward. The judge's voice changed. "Security, remain at the door." Then the side door opened, and Elaine Porter walked in with her coat folded over one arm. My father finally sat, but the room had shifted. Everyone could feel it. And once Elaine raised her right hand, there was no hiding what came next. Would you still call it a misunderstanding after a man stood up in court like the truth itself had to be kept out of the room? Would you have gone back into that courtroom knowing your father had just tried to rise before the truth could even reach the witness stand? Elaine Porter took her seat, adjusted her glasses. The judge asked whether she had served as notary for the transfer 4 years earlier. "Yes," Elaine said. Then the layers started to open. Elaine confirmed that both trustees had appeared for the original sale, that the trust language had been read aloud, and that my grandmother insisted the transfer be final upon completed payment. She confirmed my mother signed in front of her. She confirmed my father had done most of the talking. Then my attorney asked whether he had said anything after the signing. Elaine answered in the same calm tone she had used in her living room. He asked me whether the deed could be corrected later if the daughter became unstable. My father's attorney objected. The judge overruled it. Elaine repeated the line exactly. My attorney handed her the trustee memorandum dated 8 months earlier, the one claiming beneficiary instability and family need. She studied it for less than 10 seconds. "No," she said. She pointed to the stamp placement first. Wrong county margin. Then the seal impression. Too shallow. Then the signature line. Her commission initials were missing. Finally, she said, "This is not my notarization." Then my attorney called my mother. Mom walked to the stand like each step cost something. She was sworn in and kept her eyes on the clerk's desk. My attorney asked whether she had knowingly signed a memorandum to reclaim the house. "No," Mom said. Asked whether she had knowingly approved a corrective deed filing. "No." Asked whether she recognized the signature on the disputed paper. "It looks like mine," she said. "Did you authorize that document?" "No." It landed harder than I thought it would. Then came the check copy from my father's desk. The $3,200 payment to the title consultant. Then the consultant's email, subpoenaed 2 days earlier, stating he had been asked whether a completed family transfer could be delayed, clouded, or pressured into renegotiation if the owner was financially weak and personally isolated. Dad's attorney tried to argue legal review, not fraud. He said families sought clarification all the time. He said concern could be clumsy without being malicious. Inside that room, with the forged memorandum, the improper filing, the inventory list, the consultant check, the notary testimony, and my mother under oath, it sounded thin. The judge asked my father whether he wished to testify. Dad stood. He took the oath and tried to put the room back under his voice. He said I was fragile after my divorce. He said the house had always been intended to remain within proper family stewardship. Then the judge asked why he filed a corrective claim without verified trustee consent. He paused. Then he said, "I believed my wife agreed." The judge asked why he submitted a memorandum with a disputed notary block. He said, "I did not prepare that personally." The judge asked why his contents sheet listed property excluded by prior estate instructions. He said, "Those items belonged with the home." Then he made the mistake that ended him. He looked past the judge and directly at me. He said, "She only has any of this because we let her." Not had. Has. Dad kept going. "She was never meant to stand alone with family property." That was understood. My mother closed her eyes. The judge began ruling from the bench. She found the original sale supported by trust records, payment evidence, and witness testimony. She found no lawful basis for the corrective filing. She found the disputed memorandum unreliable and unsupported by credible notary evidence. She found my father's inventory and related conduct consistent with an attempt to pressure or reclaim property after completed transfer. This court is referring the questioned document and filing conduct for further review. Dad lurched up so fast his chair scraped backward across the floor. His attorney grabbed at his sleeve. Too late. Dad pointed toward our table. "This is her doing. This is what happens when you let her think she owns things." The judge's voice cut across the room. "Sir, sit down now." He took one step forward. That was when the judge said, "Security." The deputy at the door moved immediately. Another officer came in from the hall. They stopped beside my father before he reached the rail. One hand on his arm, one between him and the bench. Dad kept talking, but his words had lost shape. I only caught pieces. Betrayal, ungrateful, mine. That was the word he had always meant. A few minutes later, the ruling was final. My home, truck, dining set, sideboard, and every other listed item were mine. The court denied his claims, vacated the filing challenge, and barred further interference absent new lawful grounds. I did not cry. I just sat there and listened to the clerk read the order into the record, line by line, like someone fastening bolts into a door that had finally closed. Afterward, the hallway felt brighter than it had that morning. Mr. Bell shook my hand. Elaine gave me a tired nod. My mother stood 10 feet away, holding her purse with both hands again. She said, "I am sorry." I said, "I know." Then I picked up my box and walked past her. Dad was at the far end of the corridor with his attorney and 2 officers nearby. Evan stood by the window, looking smaller than I had ever seen him. No one stopped me. No one asked me to sit down, understand, forgive, or come home and talk like a family. Outside, the air was cold. I set the banker's box in my truck and sat behind the wheel without starting it. Space. That was the feeling. Just space. That evening I went home, unlocked my own front door, and put my grandmother's recipe box back in the sideboard drawer where it belonged. Then I set one place for dinner at my table. My parents finally knew the truth. The court knew it too. I still do not know whether my mother regrets the silence more than the lie, or whether my father regrets losing control more than he regrets losing me. But sometimes I wonder whether people like that ever mourn the harm they caused, or only the moment they can no longer reach what they once called theirs.